So the question is, in a residential lease, should a tenant be allowed to make a repair to the premises and deduct the cost of that repair from the rents? We call this repair and deduct in the state of Georgia. In 1963, in Abrams v. Joel, a court case in which the judge decided this could be done, sets a precedent for us in common law. However, what that particular court case did not do for us was establish what constitutes a breach of duty on the part of the lessor. It also doesn't help us to understand what is a reasonable period of notice by the lessee to the lessor to make such a repair. There was a court case in 1977, Lipschutz v. Shantha, in which the Abrams v. Joel judgment was invoked, and the judge in the Court of Appeals declined to accept that on the grounds that in 1970 there had been an amendment to the Georgia statutes, Title 44, Chapter 7, Section 13, in which language had been submitted by the House to the Senate which would include a provision for a repair and deduct. That language was specifically omitted from the law, or from the amendment to the law, and the amendment was passed. Well, the judge, being aware of this, it was Judge Webb, I believe at the time, said that he didn't feel like it was the court's right to subvert the legislative will. I couldn't agree with him more about that. And then again in 1981, we had another case which tested Abrams v. Joel. It was Swim-Dixie Pool versus Kramer et al. And in that particular case, once again, the judgment was not permitted into the case. So really, the merits of this particular ruling have never been further tested. But having said all of that, I guess it's important to understand that it's the local legislative mindset that's more important than what's in the law. But in the residential world, because our court cases are typically of a lesser cost, we typically don't see these kinds of rulings getting into the appeals court and therefore becoming part of case law. And of course, since magistrate's court is not a court of record, we're not seeing the judgments that are being made right now being made a part of the record. But if your judge believes that repair and deduct is a legitimate outcome, then that probably is going to be a legitimate outcome in your jurisdiction. There's, I'm sure, more about this. I've written more about it actually in a written blog that's associated with this particular video blog, and you can read that if you like. You can find it on our website at 3optionsrealty.com under the same title. And but I'd like to talk to anybody that has more information about this particular concept. If you care to discuss it further, you can either comment on this video blog, you can drop me an email, or you can send me a phone call. Either way, I'd love to talk to you about it. And until then, I wish you well, and I thank you for listening.